inviting you to join us on Talk What You Know, Hard Talk, the new edition, where you become the expert. The barber, the beautician, the beauty shop, those are the people we're going to talk to, the grassroots people, the people in the community who really knows what's going on. You know, the street knows what's happening before anybody else. So we encourage you to join us each and every Wednesday at 11 a.m. on Talk What You Know, Hard Talk, on NewOrleansTalkNetwork.com, where you become the expert, where we explore politics, business, ecclesiastical issues, and everything that impacts you on a daily basis. We encourage you to join us every Wednesday at 11 a.m., where we bring you exciting people from the community, talking what you know, hard talk, no holds barred, where you become the expert.
Here at Jones Insurance, your full-service agency, let us take care of all your insurance needs. We provide homeowners insurance, flood, rental, commercial, auto, and life insurance. Don't let the unexpected tragedy destroy your family's future. Here at Jones Insurance, 7603 West Bank Expressway, Monroe, Louisiana, 772. Contact Lois at 504-348-1492.
Hi, I'm Sheriff Joe Lapinto, and you are watching the New Orleans Talk Network.
During times of family stress, if you need a church to hold your funeral services or a hall to hold your repast, you can contact us at Bethesda Community Event Center at 504-348-0132. We can accommodate all your repast and funeral needs, from a preacher to perform the services, to an organist that plays the music, the ability to stream it live for those who can't make it, and more. During your time of need, all of your arrangements can be made under one roof here at Bethesda Community Event Center. We're here to serve you. Give us a call when you're in need at 504-348-0132. Give your loved one a great homegoing event. Come second line at our...
It's like a jungle sometimes. It makes me wonder how I keep from going under. Standing on the front stoop, hanging out the...
Welcome to Talk What You Know, Hard Talk Edition, here in the New Orleans Talk Network studios in New Orleans, Louisiana. I'm Pastor Don Laura Jones. Today we're going to look at the Supreme Court and the future of your voting rights. Actually, your voting power. Today we're going to talk politics and power. We're going to talk about politics and power. Can you imagine a Congress without an Adam Clayton Powell, a Shirley Chisholm, or a Charlie Rangel? Can you imagine a Congress without a Congressional Black Caucus? Well, you should start trying to imagine it, because there's a case pending before the Supreme Court that will have long-term consequences that will reverberate throughout this nation. Now, we're spending a lot of time dealing with things that are rabbit hole driven, that brings you down the rabbit hole. And I don't think a lot of people are paying attention to this case that's going on now. And this case will have an impact that will literally gut the Civil Rights Act of 1965. Obliterate it. Make it as though it's non-existent. And that's so important for you, and it's so important for me to understand it. And I don't hear people talking about it. As a matter of fact, you know, this show is about the man on the street. I don't even hear the man on the street talking about it. I hear a lot about inflation, the cost of living, um, police over-enforcement, ICE over-enforcement. I'm hearing all those things. Those things are flooding the zone. And I believe that that's an intentional move because the Supreme Court of the United States on October the 15th heard oral arguments in a case that could be a landmark case that can totally determine if your vote counts or it doesn't count. How you will be represented across the United States. And that case is a unique case. It's Louisiana versus Callais. That's the case. Nobody's talking about it. And to get a clear understanding of that case and understanding what's going on with it today, we're going to talk about it here on Talk What You Know, because it's going to have, if the oral arguments are representative of what the vote more than likely will be, there's a lot at stake. And what the court is contemplating is whether or not in historical acts of discrimination can be reversed by congressional law. What do I mean by that? A lot of laws were passed that sort of eliminated your capacity to participate in the economy, eliminated your capacity to participate in the electoral process. And what Congress did, Mike, put up that clip of the Supreme Court. Yeah, no, that one right there. Put that clip up there. The one of the Supreme Court. Now, this is the current Supreme Court of the United States. This Supreme Court, unfortunately, is reflective of the Supreme Court of 1866. Because what happened was that after the Emancipation Proclamation, Congress passed the first Civil Rights Act in 1866. President Andrew Johnson vetoed it. Congress overrode his veto, and President Andrew Johnson weakened that Civil Rights Act, took all the teeth out of it. And it took almost, and then as you know, you had a whole series of Congress going back trying to correct it by the 13th, 14th, 15th amendments, trying to correct it. And you might want to slow it up, buddy, stop for a minute. And the Congress passed the 14th, 15th amendments, 13, 14, 15 amendments, trying to put some teeth into citizenship and your right to participate in the American process. And then you had a whole series of southern states that instituted black codes and voting laws that prohibit you from voting. And it took almost 100 years. And then you got the 1965 Voting Rights Act that had some key provisions in it, but didn't go far enough. And so Congress came back and added a section to the Civil Rights Act called Section 2 and Section 5. In the 1980s, in the renewing of the Civil Rights Act, there was a young attorney by the name of John Roberts, who was in the Reagan administration. And he thought that the Civil Rights Act was unconstitutional. This is a young lawyer. That same young lawyer today is now the Chief Justice of the United States Supreme Court. And you know what? Time oftentimes don't neutralize your positions. Time oftentimes don't change your position. So before the court today, in Louisiana versus Callais, you have a case that could set you back to 1883, when the original Supreme Court struck down major provisions of that weak Civil Rights Act. Now, I hear people say all the time, voting don't impact me. Votes don't count. If you don't think they count, watch what's going on. You have a First, they struck down Section 5. Let's talk a little bit about Section 5. Section 5 was a pre-clearance component. Actually, some of you may know, I was in politics for about 15 years. Section 5 is what allowed me to become an elected official. Because some plaintiffs sued Jefferson Parish saying that the way they drew the local council districts, school boards districts, and state representative districts violated Section 5. Federal court came and said that's correct and forced local government to redraw these districts to not guarantee that African Americans had an opportunity to get elected, but just created an opportunity for them to get elected. And so when Eric Holder became the U.S. Attorney, Shelby Conard sued the Justice Department, and they had Section 5, the pre-clearance section, overturned. And what that did is that it sort of created an environment where those southern states that had historically put in institutional processes to eliminate your capacity to fully participate, to really eliminate your power. When the Supreme Court struck down Section 5, it eliminated the pre-clearance requirement, whereby now they didn't have those southern states when they reached, put that map up again, Mike, those southern states when they had to get pre-clearance no longer now have to get pre-clearance. That, at that time, did not have the dramatic impact. As a matter of fact, Chief Justice Robert in his ruling said that although we have ruled Section 5 unconstitutional, Section 2 still exists. So Section 2 is a national prohibition on curtailing people's right to actively participate in the political process, eliminating your power. Now here comes Louisiana versus Callais. And that's the case that we want to talk about today. And that's the case we want to explain its impact on you, because it will impact you if the court goes the way the court in 1883 did and struck down all the major provisions of the Civil Rights Act. As a matter of fact, they said Congress could not regulate private discrimination. Isn't that amazing? Now, Congress can pass laws that allow discrimination, but it cannot regulate private discrimination. That's an oxymoron. So the very protocols and the very things that give you the rights and the very things that curtail the rights, that's what the Supreme Court is dealing with. And this Supreme Court, unfortunately, see, justice isn't balanced. The scales of justice are not balanced, regardless of what anybody tells you. Because if you look at some of the major decisions of this Supreme Court, this Supreme Court has tried to undo the 13th, the 14th, and the 15th Amendment. Yes, that's what they've done. And so, as I've been talking to the man on the street about this, they're not talking about it. They're not talking about it because we're not talking about it. And because it's a reciprocal situation. The man on the street knows what's happening before the institution. And if the man on the street isn't paying attention to this, and if the man on the street doesn't realize how this is going to impact him, because this is going to reverberate, if this Supreme Court rules the way people think it's going to rule, this is going to reverberate across the nation. This is going to, Texas just recently done something that's rarely done. The president called out on national television and said, hey, give me 5 more congressional seats in Texas. I want to make sure that under no circumstances the Democrats take control of the House of Representatives in 2026. So what Texas did, never been done before or rarely been done, They decided they're going to redraw the congressional districts so that they eliminate Democratic districts and create more Republican districts. California does that. Texas does that. California responds in kind. So now we have a gerrymandering political war going on. And that's just what they want. Because if you notice the Supreme Court's protocol, they set this up. They set this nuclear political war up when they gutted Section 5 of the Civil Rights Act. And they did something that the court rarely does. And we're going to look at that shortly. They did something. They heard a case, didn't decide on it, sent that case back and instructed the plaintiffs, this is how you draft a case that will give us an opportunity to strike down Section 2 of the Civil Rights Act and say that Civil Rights Act, that the provision of the Civil Rights Act's Section 2 violates the Equal Protection Clause. They gave them the play to run. And you know what happens? Louisiana, who in 2023 was fighting for the 2 congressional districts in Louisiana, in 23 led the charge, now with 16 other states, most of them southern states, and the Justice Department is going back less than a year later saying, you know what? We made a mistake. We want you to revisit this. And we want you to revisit, and we want to ask this question. Although Congress passed the law, and Congress did this in the 1980s, although Congress passed this law, and this law has been in position for decades, we now want to question the validity of Section 2 and see if Section 2 violates the Constitution. And all Section 2 and the 1965 Civil Rights Act did was put teeth into what Congress intended when it passed the 13th, 14th, and 15th Amendments. We'll be right back after this short break, and we're going to delve into this Louisiana versus Callais case that very few people are paying to, that if the Supreme Court rules the way the oral arguments suggested they will rule, you'll be back to 1833 as it relates to political power. And then it won't matter if you have $1 to buy food. It won't matter if you have $1 to send your child to the school you want them to send to. It won't matter if you have a job, because all of your political power will be erased. We'll be right back.
Now New Orleans has a choice. Download the New Orleans Talk Network app for your mobile device or listen at www.neworleanstalknetwork.com.
Are you looking for a home to live stream your next event? Give us a call here at Bethesda Community Event Center, the only place on the Gulf Coast that can host and broadcast live your wedding reception, your baby shower, business seminar, and any other special event. Give us a call at 504-708-9454 for more details.
Bethesda House of Prayer, Bethesda is a church for non-traditional worshipers, a church designed for those who love God's Word. Would you like to attend a church where believers and non-believers can choose to worship together? A church where cultural differences does not get in the way of God's message. We invite you to be our special guest. Our services begin 9 a.m. on Sunday, located at 7601 West Bank Expressway, Suite B, Marrero, Louisiana. For more information, contact us at 504-348-0132.
Man had to do whatever he can to get me. Baba don't take no mess. No, don't take no mess.
Welcome back to Talk What You Know with your host, Reverend Dr. Don Laura Jones here in New Orleans Talk Network Studios. We're here today and we're looking at Louisiana's 6th Congressional District, and we're looking at the case that could change everything. And what's happening behind these marble walls? What are the intentions of what's going on? And we talked to you about the 1883 cases that struck down the Civil Rights Act and the 1965 Civil Rights Act that put teeth into the 13th, 14th, and 15th Amendment. And how in Shelby versus Holden, the Chief Justice struck down Section 5, which was the pre-clearance. What that basically means, that these southern states that passed these discriminatory voting law acts, these southern states that spent a whole lot of time putting laws and things in place that discriminate against your right to vote. Like, you have to be able to read the Constitution upside down. You have to be able to count how many bubbles inside of a jar, how many jelly beans inside of a jar. You got to be able to recite the Declaration of Independence from the middle backwards up. All kind of crazy stuff like that. Institutional laws. I mean, laws on the book, the black codes, the voting laws, all those things that came out of the Mississippi Constitution of the 1890s, and all the southern states adopt that model, which really precluded your capacity to participate in the electoral process, taking away your voting power. Now, why is that important? Your voting power determines a lot. Your voting power determines if you have good schools. Your voting power determines if you have good transportation. Your voting power determines if you have good opportunities. You see, one of the things that, and let me just stop for a minute. One of the things that we don't understand, that we live in what you call a democratic republic. You elect people to represent you. I'll say that again. And I don't think enough of us understand that. We live in a democratic republic. You can stop. And we don't understand that you have to participate, and you have to be able to elect people that represent your interests. And so what the two major civil rights bill did, the one in 1866 and the one in 1965, look at those years, tried to put teeth into the 13th, 14th, and 15th Amendments and give you a right to participate in the process. What's happening now is the Supreme Court, when they agreed less than a year and a half ago that Louisiana discriminatory drawing and gerrymandered the districts precluded 1/3 of the citizens of Louisiana of having an opportunity to elect someone of their choice. And that same Supreme Court allowed those congressional districts to stand, but they did a caveat. Chief Justice Robert did a caveat. He stuck a provision in there that told Louisianians, bring this case back to us, and bring it back to us and ask us, is Section 2, the very section that allowed the remedy to cure past discrimination, is Section 2 constitutional? Because if we can knock out Section 2, then you now have no teeth in the Civil Rights Act. You now have no enforcement mechanism, and southern states and other states can gerrymander the district such that they eliminate your capacity to be able to vote. Mike, put that map up there again, because that map is important. These are those southern states that were primarily regulated by the 1965 Voting Rights Act. And those southern states now have about 18, 19 African Americans representing them. And so that's key. And so the key to it is the same state. Put it back up again, Mike. That's important. That map is important. Because that map shows you the map on the one with the 18 blue spots. That map shows you in those states how many African Americans are in Congress. That's under the existing law under Section 2. If the Supreme Court on Louisiana versus Callais overturned Section 2, the map with the 2 blue dots is how many African American officials you will have from the South representing you in Congress. That's 1883 all over again. And it never ceases to amaze me that your state, you can go it on, buddy, your state, Louisiana, that in 2023 argued for these 2 congressional districts, is now before the Supreme Court arguing against these 2 minority congressional districts. They're under severe attack. And it will not only affect Louisiana, it's going to affect every other state, not just the states, not just on the congressional level, but on the state level, on the local level. See, without Section 5, I probably would have never been elected to the Jefferson Parish Council. Because the way they drew the districts, they eliminated any possibility of an African American being elected. And these voter opportunity districts don't guarantee you an election. They create an opportunity for you to be elected. Now, this is the question. If Congress passed laws that allow for this massive discrimination, why can't Congress pass laws that curtail the massive discrimination? What is the Supreme Court thinking? Ask yourself that question. What are you thinking? When you wake up and you have no political power, do you know what that means? Laws are going to be passed that you don't participate in. Laws are going to be passed that create opportunities that you don't participate in. That will have a dramatic impact. Why do you think they fought so hard for the 13th, 14th Amendment? Why do you think they fought so hard for that first civil rights bill and to get President Johnson to pass the second civil rights bill? It will have impact. Mike, play that clip from PBS. Maybe they always say that white ice is cold and black ice. Maybe I'll let some white folks explain it to them, and maybe they'll embrace it then. Play that clip, Mike, from PBS.
Conservative majority signaled today it could upend a central pillar of the landmark 1965 Voting Rights Act, a move with the potential to reshape electoral maps across the country.
The question at the heart of today's arguments is whether lawmakers can use race as a factor when drawing congressional districts. Justices must consider whether the 2024 creation of Louisiana's second majority black district violated the Constitution. Here to break down the arguments and the case's potential effects, I'm joined by Amy Howe of SCOTUS blog and David Wasserman of the Cook Political Report with Amy Walter. So Amy, how did we get here?
So this is a long and complicated story, even by the standards of redistricting cases. So every 10 years we have a census, and then states have to redraw their congressional maps, among others. So Louisiana redrew its congressional map, and in 2022 it enacted a new one that contained one majority black district, the state's out of 6. And the state's population is roughly 1/3 Black. So a group of Black voters went to federal court arguing that the new map violated Section 2 of the Voting Rights Act, which prohibits discrimination based on race in voting, because they said it diluted their votes based on race. A federal court in Louisiana agreed with them that the new map likely violated the Voting Rights Act, and it instructed Louisiana to draw a new map. So Louisiana drew a new map in 2024 that contained 2 majority Black districts. A group of voters who described themselves as non-African American voters went to court, arguing that this map was an unconstitutional racial gerrymander, that it sorted voters based on their race. And a 3-judge district court in Louisiana agreed with them. So Louisiana and the Black voters defending the 2024 map came to the Supreme Court asking the justices to take up their case. The justices heard oral argument in March on the propriety of the map. They didn't decide the case by late June, the way that they do with the overwhelming majority of their cases, and instead decided to hear argument again in the fall and ask the litigants to brief a...
Now, you heard what she said? The Supreme Court did something. For those of you who think that white ice is colder than black ice, I told it to you earlier, but she's telling to you now. The Supreme Court did something that it rarely does. What it did was said, you know what? We're going to send this back down. We're not going to make a decision on it. And oh, by the way, in sending this down, this is what we want you to come back and argue before us. They gave them the play. So it's not, they gave them the play. And they said, oh, by the way, if you do this, we can come back in less than a year, and we more than likely can do what I wanted to do in 1980. I'm paraphrasing as Chief Justice Robert. Do what I wanted to do in 1980, destroy the 1965 Civil Rights Act and the provisions that Congress put in it to give it teeth. I'm going to take out Section 5 now, but I want to come back and take out Section 2 later. And oh, Louisiana, here's how you do it. You get some plaintiffs to claim that they are non-black and that their 14th Amendment protection uses the very same amendment that was designed to protect you against you. Did you hear her say it? In less than a year. Mike, clue it back up.
New question, which is whether the intentional creation of a second majority Black district violated the Constitution.
And among some of the questions that the justices asked were whether or not the Voting Rights Act and the protections in it were meant to be permanent. Here's what Justice Brett Kavanaugh said.
This court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
And so the topic that Kavanaugh was talking about there, the permanence of the Voting Rights Act, is that something that featured elsewhere in this argument today?
Janae Wilson, who was the lawyer representing the Black voters who were defending the map in this case, and some of the liberal justices pointed out that when you're talking about potential violations of Section 2, you actually look at current conditions. So this is not a question of whether or not there's a logical endpoint.
Mm-hmm. What are the potential outcomes here? How might the justices
Let's pause
decide
there, Mike. Let's pause there.
So there's a couple of different outcomes.
Now, I just said, hey, I'm going to let, for those of you, and there are a lot of people out there that still today that think white ice is colder than black ice. I explained it to you. Now let a Caucasian explain it to you. And what she told you is basically they're saying, and listen to Justice Kavanaugh. He's saying that although these laws were passed to strip your political power, and although Congress, not Congress subsequently passed laws that tried to level the playing field, it was never meant to be permanent. He's telling you that the 13th, the 14th, the 15th Amendments, parts of the Constitution, were never supposed to be permanent. I thought the Constitution was a permanent document. I thought once Congress passed something, it was the law of the land. And once the people ratified constitutional amendments, it was the law of the land. Here's a Supreme Court justice suggesting to you that remedy that Congress passed and the states ratified are unconstitutional because Congress came back and passed the 1965 Civil Rights Act, and Congress in 1980 passed legislation that amended that 65 Voters' Rights Act, that added Section 2 and Section 5, that gave it teeth to enforce the intent of the law. He's telling you that was never designed to be permanent. That's literally what he's saying. And I wanted you to hear it from someone else, because you may not would believe me, but let me tell you something. You don't have to believe me because I lived it. Let me tell you how I lived it. Give you a real sense scenario. And this came to me, and I thank the Holy Spirit for this, because I called an associate of mine yesterday and asked him to be on the show. And he said that he was out of town, but he would be glad to do it. And he said, hey, man, do you know that I was in a discussion? And they said they specifically passed term limitations to eliminate your capacity to run again. Yes. They changed the law. Changed the law locally to eliminate your capacity when you were at your strongest level to run again. That's insidious, and I thank God that we've had two excellent council people that came after me. But what if that was not the case? And what these people did, and the guys sort of remind me of it, they set up this charter commission. And this charter commission task was to change the charter. And the number one thing they did in changing that charter was they eliminated how many times a district council person could serve, an institutional change. But let me tell you something. They didn't limit how long the sheriff could serve. And at that time, the sheriff had served 20 years. They didn't eliminate the time the clerk of court could serve. There's the same clerk of court that got elected when I initially got elected in 1991. That's the same clerk of court who's serving today. They didn't eliminate the time the registered voter could be elected. They didn't eliminate no local seat. They didn't put limits on no local seat but the council district that I served in. You think your vote don't count? You think legislation don't count? They limit no other local seat but that council seat. And that's what the Supreme Court is attempting to do today. They are attempting to institutionalize. If you're not paying attention to it, they're institutionalize and bring us back as it relates to voting rights to 1893. We'll be right back after this short break on Talk Hard Talk Edition. But we're deciding if your vote's going to count or not.
Home is filled with pain, and it might not be such a bad idea if I never went home again.
The New Orleans Talk Network, now on your mobile device, on your computer, in your ear, and interactive. It's new, it's innovative, and it's on your mobile device. Android, iPhone, iPad, and on your computer. Take us wherever you go. Because we're interactive. 504-341-TALK. That's 504-341-8255.
Here at Jones Insurance, your full-service agency, let us take care of all your insurance needs. We provide homeowners insurance, flood, rental, commercial, auto, and life insurance. Don't let the unexpected tragedy destroy your family's future. Here at Jones Insurance, 7603 West Bank Expressway, Monroe, Louisiana, 772. Contact Lois at 504-348-1492.
It's your girl Spice Divas, the marketing diva, the host of Red Lip Talk podcast. Check me out every Monday at 1 p.m. on New Orleans Talk Network. Where do I begin? We have so many amazing guests, from politicians, gospel artists, barbers, beauticians, entrepreneurs, and so much more. If you want to be a guest on our podcast, definitely tune in so you can see what we're doing every Monday at 1 p.m. on New Orleans Talk Network. Mwah!
Imagine a room filled with hope, strength, and stories of survival. On November 8th, Bethesda Community Development hosts the Thrivers Celebration of Life Banquet, honoring cancer survivors right here in Marrero. Your donation, big or small, helps us give survivors and their families a day to celebrate and access the resources they need to thrive. With just $25, $50, or $100, you can make a difference in someone's journey from diagnosis to hope. Please support local survivors and help Jefferson Parish grow stronger together. Donate today, and let's keep hope alive for every fighter, every thriver.
Immaculate ways of action. Little brother, I know that times is hard. And listen. Keep your mind on God. Stay clear of danger and harm, and you'll get along. I sing this song for little brothers out there in the street, struggling to make ends meet. Gotta hold the heat, struggling so.
Welcome back to Talk What You Know, Hard Talk Edition here in the New Orleans Talk Network studios. Man, we're so glad to be with you today. We're talking politics and the power of politics, and your vote counts. And we're looking at a case that's before the Supreme Court that a lot of people aren't talking about. And I encourage you to start talking with your neighbor, start talking with people at the table, start talking in the stores, because this case will reverberate throughout the entire nation. And let me tell you something. I'm not a Democrat. I'm not a Republican. I'm an independent. And I want my vote to count. And if Section 2 fails, you have the potential of wiping out at least 19 African-American seats in Congress. Now, in the Deep South. Now, wiping those seats out is not about new ideas. It's not about more votes. It's about just redrawing the districts where gerrymandering does the very same thing they're saying that a race-based conscious district represents. Now, let me tell you how silly that is. This very same Supreme Court, less than 3 weeks ago, ruled in a case that ICE, you know, the people wearing the masks, going around harassing people today. ICE, you've seen some of that, I know you have. ICE could use race, job description to stop you and validate whether or not you're an American. So this is my question. If ICE can use race-based remedies to enforce whatever they enforce, and I don't know what the hell they're enforcing. They're enforcing something, well, let's just keep it straight. ICE, the Supreme Court ruled that ICE-based racial remedies and job-based remedies can be used to identify individuals who should be in this country or shouldn't be in this country. What's the difference? What's going to happen is that states like Louisiana, Alabama, Georgia, South Carolina, North Carolina, Texas, and Florida are going to go all the way back to 1893 all over again. That's what's potentially going to happen. And that's why we have to start talking about these things, because it's going to impact entire communities. It's going to impact where your hospitals go, where your schools go, where your roads go, what kind of grants you have. No Adam Clayton Powell in the Congress, no Head Start. That's right. No Adam Clayton Powell, no Head Start. We don't give Powell credit. But Powell stood up as chairman of that committee and took on those committees and made some good positive things happen. I want you to hear Janae Nelson's argument before the Supreme Court, just a little excerpt of it. Now, you can go on YouTube, you can go on Chat GPT, you can go on Perplexity. What's that other one? DeepSeek, that Chinese AI. Don't be afraid of that Chinese AI. Because you know what I've learned? By looking at Al Jazeera America English version, I get to hear different things that I don't hear from our social media and local media. Yes, right. I listen to Al Jazeera American style because I want to get a diverse view. And what I'm telling you is that you're going to have to go and listen to these oral arguments. And I want you to hear Janae Nelson's. She's the one that argued this case in 23 when she had the Justice Department and the Louisiana Attorney General on her side. Now, less than a year later, the Justice Department is on the other team's side, and the state of Louisiana is on isn't that weird? You don't find that weird? That just, know what happened? You got a Republican elected as the Attorney General, you got a Republican elected as the governor, you got a Republican elected as the President of the United States. Now they control all the apparatus, so now they're on the other side. That's why your vote counts. Mike, play Ms. Nelson's argument before the Supreme Court. She lays it out. Listen to this.
We will hear argument first this morning in Case 24-109, Louisiana versus Callais, and the consolidated case. Ms. Nelson.
Thank you, Mr. Chief Justice, and may it please the Court. A mere 2 years ago, in Allen versus Milligan, a case nearly identical to Robinson, this Court noted that under certain circumstances, it has authorized race-based districting to remedy state districting maps that violate Section 2. Louisiana affirmed findings that, six appellate judges affirmed findings that Louisiana, in the face of extreme racially polarized voting, packed and cracked Black voters, and it rejected 7 non-dilutive maps in favor of one that would give its 58% declining white electorate entrenched control over 83% of the congressional districts. Louisiana's creation of a district to remedy that discrimination and to ensure that Black Louisianans have an equal opportunity to participate in the process is constitutional. Precedent from Brooks to Milligan, from Ex parte Virginia to SFFA confirm that. And 3 facts guard against indefinite use of race. First, not all Section 2 remedies center race. Second, when racialized politics and residential segregation wane, so will the ability to satisfy jingles. Third, almost every redistricting map is replaced decennially. My opponent's late-breaking and recordless facial and as-applied challenges seek a staggering reversal of precedent that would throw maps across the country into chaos. If SB 8 is unsatisfactory, the proper recourse is to remand and adopt one of the many alternative maps that address the Section 2 violation and satisfy the Constitution. As this Court noted in Milligan, Congress is undoubtedly aware of Section 2 precedent and can change it if it likes. But unless and until it does, statutory stare decisis counsels staying the course. I welcome your questions.
Congress can change it if it wants to. Congress reauthorized it under President Bush. Overwhelmingly, both Republican and Democrats would have changed. You see, the Supreme Court is asking a very dangerous question, and I just want to read it for you. If race must be considered to protect Black voters, does that make the Voting Rights Act itself unconstitutional? I'll say it again. If race must be considered to protect Black voters, does that make the Voting Rights Act itself unconstitutional? What a setup. What a setup. That defies logic. That's inconsistent with reason. If race was the primary set of circumstances that excluded your right, why can't race be a part of the remedy? So you got to understand this. You got to understand when Roberts was that young judge in the 1980s in the Reagan administration, his mindset hasn't changed. What they do is they just gradually chip and chip and chip and chip and chip till they eliminate. And that's what they're trying to do. Section 2 of the Voting Rights Act allow for you to use intent as a criteria. You see, because you can mass it like they did with here in Jefferson. You can set up a charter commission. Oh, the charter of Jefferson Parish said, well, we can set up a charter commission. And we're going to stack it with people from the business council, from this group, from that group. And we're going to come back and we're going to let me tell you what they did. They not only put term limits in place, they went back and reestablished the council structure almost exactly like it was pre-1990. They did 2 at-large council seats and 5 district seats and made anybody eligible in the entire parish to run for those 2 at-large seats. And you've never had an African-American serve in any one of those at-large seats, although African-Americans make up almost 30% of the population. And then they set it up where the council chairman will alternate between the 2. You see how sinister it is? How the institution itself can put a protocol in place, and that's what they're doing now. And we're not paying attention to it. They told the Callais group, the non-white group versus Louisiana, this is what you bring back to us. And if you bring this back to us, then we more than likely can give you the ruling that you're looking for. That's sinister. And you know what's happening? We're not paying attention. Because if Section 2, that's right, if Section 2 is eliminated, it's not only going to pack Louisiana, it's going to reverberate your entire nation. It's going to affect federal, state, and local elections. It's going to impact your ability to participate. Because we're still a polarized country. Yes, we're still a polarized country. You see, President Obama got 46% of the Caucasian vote, which was historic. That was a miracle. That was a miracle. And what you have to be able to do is to be able to unite with the 46% of the people who say, all I want is a level playing field. But if you cannot unite with those 46% of the people who say all I want is a level playing field, and the 45 other percent redraw all the districts where you can never win, what does that do? That eliminates your voting power. It eliminates it. We're going to take a short, quick break, and we're going to come back with some possible remedies to deal with this. Might take a short break. I got to just, man, this is just incredible. Just take a short break.
Man, it's really hot. Well, it's too hot to sleep. I'm too cold to eat. I don't care if I die now. Winter night in Harlem. Oh, radiator won't get hot.
Now New Orleans has a choice. Download the New Orleans Talk Network app for your mobile device or listen at www.neworleanstalknetwork.com.
Are you looking for a hall to live stream your next event? Give us a call here at Bethesda Community Event Center. the only place on a golf course that can host and broadcast live your wedding reception, your baby shower, business seminar, and any other special event. Give us a call at 504-708-9454 for more details.
Bethesda's the house of prayer. Bethesda's a church.
But not everyone wanna fall to the toes and strife.
Welcome back. Welcome back to Hard Talk. Talk What You Know. Hard Talk edition here in New Orleans Talk Network Studios. Listen, politics is a engagement sport. If Section 2 is overturned, you're going to have some serious problems. Now, here's what we can do. Here on Talk What You Know, Hard Talk Edition, we diagnose the problem, we explain the problem, and we also give you possible remedies. Because anybody can diagnose the problem. The question is, what are the remedies? First thing we need to do is we need to start educating people. I mean, black, white, Hispanic, because all of this has an impact. And when we start educating people about what Section 2 really stands for, it'll make a difference. Number 2, you got to vote. Because local elections shape how districts are drawn. And we got to make people realize that their vote count and their vote is important. And we got to engage. Engagement is so key. We got to stay engaged. We got to let people know that they can make a difference, that they are not hopeless. You see, you had almost 7.5 to 8 million people out on the street over this weekend. Peaceful protests, engaging, letting people know that you can make a difference. And it's so important. It's so important. And that's one of the, because your vote counts. We have to stay engaged. We have to make sure that we matter in America. Democracy counts. Democracy is not about convenience. Democracy is determining whether or not you will be represented in a democratic republic. Look, it was so good being with you for Talk What You Know, Hard Talk Edition. This is Pastor Don Laurie Jones. Look, keep thinking, keep questioning, and keep talking what you know, because that makes a difference. Talk What You Know, Hard Talk Edition. We'll be back with you next time, same network, same social medias. Look forward to seeing you next time.
Soon it will be their turns to try and save the world. Right now they seem to play such a small part of.
During times of family stress, if you need a church to hold your funeral services or a hall to hold your repast, you can contact us at Bethesda Community Event Center at 504-348-0132. We can accommodate all your repast and funeral needs, from a preacher to perform the services, to an organist that plays the music, the ability to stream it live for those who can't make it, and more. During your time of need, all of your arrangements can be made under one roof here at Bethesda Community Event Center. We're here to serve you. Give us a call when you're in need at 504-348-0132.